All right, friends. Apparently people watch these videos, which is surprising to me and actually like learn something. So let's take a little bit deeper dive on a question that I get asked quite a bit, in which it seems like there's a reasonable amount of anxiety floating around as to what to do if a tenant is uncooperative, and in such a way or to such a degree that it impacts an owner's ability to comply with their building performance standard requirements. Because remember, all building performance standards are written such that the requirements fall to the owners. This also came up during recent office hours with our State Department of Commerce, so let's talk about it. Two big disclaimers first. Number one, this video and all videos I post on the internet are for educational and informational purposes. Why do I say things like this? It's because I'm a lawyer, but please don't get your legal advice from social media. All buildings and all leases are different. That's what makes this both challenging and interesting. And if you have specific questions, reach out and I can see if I can help you with those specific problems. This is just for educational purposes. Second, in this video, I'm generally talking about Washington state law and Seattle's municipal code. All state and local laws vary. Digging into Washington and Seattle because that's where I'm based. And also we have some unique nuance given the timing and way that our building emissions and performance standard were implemented. So I'm going to get a little bit in the weeds, but just want to be clear that that's what I'm talking about. So what do? There's at least four options. And so let's talk through them. First, try being human and having a conversation. Communicate early and often regarding expectations for tenants in the space. I'll get to how to document those in leases in a minute here, but in my experience, and I spent a significant amount of my career doing insurance coverage litigation, risk management, I've found over and over again that clear communication is one of the most cost-effective and underutilized risk management strategies. Save yourself some money and just clearly communicate early and often. So that's number one. Number two, know what the law says. All BPS laws are different. And Washington State and Seattle both have some unique nuances to them. I covered this in another video with respect to penalties, which I'll link. And I'm going to generalize here, but a couple things to keep in mind that relate to tenants. So under Washington state law, owners cannot pass penalties on to tenants as long as tenants are providing access and being responsive to owner requests. Talk about why I'm putting that in quotes in a minute. The updated rules and revisions, we just went through a rulemaking process to our standard 100, which is the actual language as to how the standard is implemented, provides some interesting clarification. So it actually says the inability of tenants and building owners to find a mutually agreeable time is not being unresponsive. So presumably trying to avoid the situation where an owner sets a meeting and says, well, the tenant didn't show up, and then says, well, they're unresponsive, so we're just going to pass through the fine. It's not very cooperative, and so trying to avoid that situation. The updated rules also say that building owners seeking relief through an exemption or extension, which I'll talk about in a minute, must provide documentation of how the tenant is being unresponsive. So be ready to produce presumably email chains, calendar invites, other forms of communication, access denials, work orders, things like that. We'll get to more to that in a minute. So that's, again, a generalization, but some of the relief or avenues under state law. Now, if we look at the city of Seattle, it's interesting to contrast. There are some opportunities under the code that provide owners with different opportunities for relief. So essentially stating fines cannot be issued to an owner if they can't comply due to a tenant's refusal to provide information. So kind of trying to avoid that situation where owners like, hey, my hands are tied, tenant's not providing presumably utility information or something else. And the owner's fined anyway, even though it's the tenant who's sort of blocking the ability to comply. The code also gives the city the ability to directly fine uncooperative tenants, so kind of that direct avenue of relief, and to reduce an owner's penalty by the amount attributable to a non-responsive tenant. So some additional opportunities under Seattle's code for relief for owners who may find themselves in these situations. These are all good reasons why tenant data sharing, cooperation, access, things like that should be addressed in a lease. I'll talk about that in a minute. Third, owners can potentially file, again, under Washington state law for extensions, presumably to get more time to deal with a tenant, or maybe an exemption. Again, this came up on a recent webinar on our new rules, and the question was basically whether an uncooperative tenant would constitute circumstances that are, quote, beyond the building owner's control, because there's a potential 2-year extension available under the new rules if you can demonstrate circumstances beyond the building owner's control. The rules provide sort of this non-exhaustive list of conditions that could warrant an extension, and Commerce was clear and the rules are sort of clear that to apply for extension or exemption, I'm not exactly sure what exemption would be available, but extensions potentially beyond the building owner's control. The owner would have to provide documentation and make a compelling case that would justify relief. So again, you have to provide documentation as to how tenants are being uncooperative, and it would have to fall outside these sort of maybe like gotcha moments of setting a meeting and not asking if the tenant is even available. So potential options for like an extension under Washington state law, maybe an exemption if you can find a way that that fits under there. Again, have to be ready to, I would assume, provides pretty substantive evidence that tenants are being unresponsive. So wrapping all of those together is sort of the fourth option, which is addressing these and other issues in the lease so that everyone's on the same page. Clarity generally benefits all parties, and you can do things like define what providing access and being responsive means. Does it mean a business day? Does it mean 2 business days? Does it mean access during business hours or before or after? You can outline data utility sharing requirements. You could also require tenants to attend, like a building-wide lunch and learn on BPS compliance and what's expected. So everybody knows what's expected, everybody knows what the rules are, and everybody knows what their lease says. So these are just a few ideas. Leases really can and should be used as tools to manage many of these risks. I've got lots of other videos on the specific topic, so I'll link those below. But if you have specific questions or need support, happy to help. Reach out. We can see if we can support you in that, in whatever challenge you're facing. And if you have other ideas of what to do with uncooperative tenants, feel free to drop them in the comments. But the theme here, again, is let's all work together towards compliance. Building performance standards are really forcing owners and tenants to work together based on the way that they're designed. Requirements fall to owners. Tenants, in many cases, lease much of the space. And so the theme again here is really, let's work together. Let's be cooperative. Let's all skip together towards a decarbonized future, and hope to see you there.